notice of non-joinder of Mr. Nichols' motion for mistrial and objection to mid-trial substitution of the trial judge file. Yeah, I like that motion from Bruce Harvey. It was so well written. It was so well. I had to read it. There was no need to explain. He really dumbed it down to my level. I mean,
Glanville's level.
Yeah, no, he didn't use crayons.
Oh, okay.
What was it? Page 72?
Yeah, I think that's what he said earlier.
Dun, 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 dun. Sorry for the blinking.
It's okay. Hopefully nobody's epileptic.
But we are down to exhibits on page 72. This is just the exhibits.
Oh,
Something specific on 72?
No, this is about...
I said start at 72, I thought.
This is about... motion to disqualify. This is just an exhibit. Let's go up again. Yep. It's easier to go up than down. Comes now, Mr. Jeffrey Williams, by and through undersigned counsel, and hereby files this response to state's motion to restrict extrajudicial statements, filed on July 23rd. Motion to adopt motion for fair and constitutional trial on behalf of Mr. Stilwell, as well as Diamante Kenrick's motion for mistrial, both filed on or about July 23rd. And 3, notice of non-joinder of Mr. Nichols' motion for mistrial and objection to mid-trial. Mr. Williams is innocent of all crimes in the above referenced indictment. Response to state's motion to restrict extrajudicial statements. On or about July 23rd, the state filed a motion to restrict extrajudicial statements. Mr. Williams' counsel statements referenced in the state's motion do not violate the plain language or spirit of any ethical rule. In contrast, the state failed to alert this honorable court that before and during jury selection, when potential jurors were not fully charged to avoid all media reports concerning the indictment, the following occurred. Oh, we have examples. Fox 5 press conference with Fulton County District Attorney Fawny Willis, Esquire, dated May 10th, 2022. District Attorney Willis speaks from 11/21 to 1907, 2037 to 2113, and again from 22/19, 24/18, including the following. Oh. In reference to District Attorney Willis claiming her priority is to prosecute gangs. And there's a reason for that. They are committing conservatively 75 to 80% of all violent crime we are seeing in our community. Yeah, I do believe that includes all the possible gangs, not potential. Just this one.
Well, then if you take into consideration that the definition of gang has been expanded to include like everything, then really you can put all crime under it.
Yeah.
Yeah, what's the word, Miss Love used? It is
criminal.
No, you have the proper street gangs.
Oh,
you have the criminal street gangs, and then you have the mixed street gang, which she claims the YSL is. So she's really expanding on keeping it extremely vague.
Which you want for a criminal prosecution.
Oh. And so they have to be rooted out of our community. I said just a week or two ago, it does not matter what your notoriety is, what your fame is. If you come to Fulton County, Georgia, and you commit crimes, all of the defendants are born and raised in an area about the size of a matchbox in Fulton County. So it's not, if you come here, no, they are there.
They are Fulton.
And certainly, if those crimes are in furtherance of a street gang, then you're going to become a target and focus of this district attorney's office, and we will prosecute you to the fullest extent of the law. We are proud to bring forth this indictment and hopefully to bring justice to a lot of the community who were victimized through the cause you'll see in this indictment. But more importantly, the most important thing we are here to do is keep this community safe. And we believe removing these 28 defendants will keep Fulton County safer. For reference, crime in Fulton County has risen since these people were arrested. Hey, Kat. From Elia, living my best life. Thank you so much for your super chat. That is so sweet.
Thank you so much. I just set up a redirect too. So I have this segment going, but I'm bad at setting up redirects, but everyone will end up spilling over here when this motion closes down. We'll party in here.
Oh, thank you. Thank you.
Yeah, it'll be a good time. Time traveling.
Oh, you're doing
the syndication through StreamYard.
Okay, yeah. A premiere.
Well, that is $5 into the to the Wheel of Regret fund because it's Friday.
I might participate. I don't have all the options available to me, and I'm going to tell you I don't have mayonnaise. I'm not doing the spoon of mayonnaise challenge. I'm not doing it.
I think you may need to get some Vegemite and do it on stream with Hella. I've never had it before.
Yeah, for you guys who wonder, what's the Wheel of Regrets? This is the Wheel of Regrets. For every $50 in Super Chats, gifted memberships, or PayPal, I will spin the Wheel of Regrets, which has some alcohol and making me eat interesting things.
We'll have to pretend all of it is rum. All I have is spiced rum.
So if we had reached $50, I would have had a teaspoon of. Where is it? Where are you? Wild sauce, which is habanero, blueberries, lingonberries, garlic, and stuff. But we aren't there yet. So, I hit the shot. Oh, well, yeah. But we are not here for this just yet. We need to read the motion. Let's see, where did I... There it is. Oh, thank you for Slidey Pie over at Rumble says, I was 15 when I had my first beer. I think I was about 4 by mistake.
Actually, yeah, I think I had my mom's eggnog with some bunch of alcohol in it when I was 5 or 6 by mistake. I took a drink.
Oops.
I thought my father's whiskey was apple juice when I was about 3. Oh, this.
Oh, you just start chugging it because you don't realize it right away, right? Because when you're excited, you're just like glug glug.
Yeah. You really don't understand alcohol and.
Yeah, I don't have a memory of it for apparent reasons. But my father he was very amused until my mother wondered, what's going on here? He drank my whiskey. He did what? My father has a special kind of humor. Yeah, but all of these is from that press conference. And below is a link to episode 3 of the podcast King Slime, the prosecution of Young Thug and YSL, released in August 2023. During voir dire and prior to jury selection, the podcast has since stopped recording episodes, but was hosted by music journalist Christina Lee and honorable reporter George Speedy. District Attorney Willis made it clear that she cannot provide specifics of the case. However, she has the following. I remember when we first took office, we were screaming from the top of the hills that there's a gang problem, and people were really actually kind of treating us like we're crazy, right? There's a gang problem in LA. There's a gang problem in Chicago. but they did not want to admit that there was a gang problem right here in Atlanta. But we kept talking about facts I knew to be true because I knew crime waves. I knew that one important person got ended, and we got a gang war for several years. And Fannie Willis got $36 million in extra funds from Fulton County and by federal grants to clear the docket after the big global event. She has used more or less all of it on RICO trials. And why is that? Well, up until recently, she wanted to become the next Attorney General of Georgia. Yeah, I don't think that will happen anymore because people tend to not like when you screw married men and then lie in church about it. So, but she will probably remain the district attorney of Fulton County.
She got probably. She got like 35 million, you said?
36 million.
36, sorry, I didn't want to exaggerate. And all she did was go after 45 people on RICO charges with that money.
Yeah.
Including Young Thug and all of them, and then Trump, and I think there was another one.
Yeah, you have the police one and then another rapper who...
Yeah, it was YFN.
Yeah. YFN.
So 36 million to go after like 45 people.
Yeah. And the docket is as big as it was 3 years ago.
Yeah. Meanwhile, you have thousands in jail, not getting a trial, not getting a...
People not even getting bond.
Lawyers.
Yeah. It is...
Priorities.
Mm-hmm. So there's transcripts. And then lawyer loves... Oh, that's some shade. Lawyer love, not the honorable ADA love. Lawyer loves motion to restrict extrajudicial statements must be rejected. It is rich, audacious, and hypocritical that the state seeks to critique as unethical the single statement by Mr. Williams' counsel, which contains accurate factual assertions. As an overarching principle, rule of professional responsibility 3.6, comment 1, makes clear that just like the framers of the United States Constitution envisioned almost 250 years ago, when they mandated that those accused of crimes are guaranteed the rights to a public and speedy trial, quote, they're quoting the Constitution. There are vital social interests served by the free disseminations of information about events having legal consequences about legal proceedings themselves. The public has a right to know about threats to its safety and measures aimed at assuring its security. It has a legitimate interest in the conduct of judicial proceedings, particularly in matters of general public concern. Furthermore, the subject matter of legal proceeding is often of direct significance in debate and deliberation over questions of public policy. Who wants to read the next part here?
Oh, I can do it. You're going to see me sit like this. So, we are looking at Rule of Professional Responsibility 3.6, comment 1, which says, moreover, comments 5A and 5B delineate certain subjects about which a lawyer could speak, which are more likely to have a material prejudicial effect on a proceeding. And those subject areas are more likely than not to have no material prejudicial effect on a proceeding. In a criminal case, comments which are more likely to have a material prejudicial effect on a proceeding include subjects relating to the following. So 1, the character, credibility, reputation, or criminal record of a party, suspect in a criminal investigation, or witness, or the identity of a witness, or the expected testimony of a party or witness. And then 2, the possibility of a plea of guilty to the offense or the existence of or contents of any confession, admission, or statement given by a defendant or suspect, or that person's refusal or failure to make a statement. And that's kind of like, I don't think we even got specific examples of. No. Like, so far we're in the clear if we think about the interviews that I'm familiar with, and I've watched a lot of them. So.
Yeah, I mean, she doesn't say there's zero example of what was said. They just here's that show, the entirety of it. I mean,
The judge needs to waste all the time she clearly doesn't have.
Yeah, Judge Whittaker, is she going to look through, 8 to 10 hours of streams? I don't think so. Dave, do you want to take the next one?
Sure. Where are we? What is more relevant to the issue at hand is the commentary relating to those subject areas more likely than not to have no material prejudicial effect on the proceedings. These subject areas include information contained in the public record, the scheduling or result of any step in litigation. This sounds very similar to ours, by the way. Every factual allegation in the statement made by Mr. Williams' counsel is contained in the public record. Specifically, Mr. Williams has repeatedly in public filings, as well as and through his counsel in open court, maintained his innocence. Mr. Williams filed motions for speedy trial. The recused judge, lawyer Love, and lawyer Hilton, have been accused of and found to have run afoul of their duties under the law. And Judge Glanville has been recused and disqualified from his trial or from his role as trial judge based on a motion brought by Mr. Williams. As this honorable court is aware, Mr. Williams' trial is televised live from gavel to gavel. The coverage is available to the public at a click of a link, even when not watched live, as recordings are maintained on www.youtube.com.
That was the court honorable again.
Thus, the likelihood that Mr. Williams' counsel's reputation or repetition of information in the public or findings of the court could materially prejudice the adjudicative process in this matter is absurd. Moreover, the jurors in this case have been provided cautionary instructions and admonitions, countless times, at least daily over 100+ days of trial, not to listen to anything related to this case.
Yeah.
So what are they trying to do? I missed the first part. Were they trying to say that he can't comment on it publicly?
Yeah. The prosecution filed a motion to disqualify the defendants and their attorneys to publicly comment on this trial. But this raises a question. This trial has been on pause for almost 2 months. A month and a half now. They will be back either August 5th or August 12th, the jury. That is the plan by Judge Whittaker. Then they have been out of court for 2 months. How on earth are they going to avoid any coverage of this trial? The disqualification of Judge Glanville, for example, that must have been headline news in Atlanta. How can you avoid that as a juror to see that? To hear that on radio, on news reports? Are they supposed to be in a dark room for months on end?
Imagine they're sequestered.
No.
I don't know what he's saying, but I can't imagine that any of this is going to affect the outcome, given the way that this case is being prosecuted and streamed live. By the way, Nick, you want to see something? This is sort of a teaser for other people.
Oh, you got the mug.
They finally came in.
Yeah.
Finally.
We had a bingo card on the
I think it was
Jodi Arias trial.
Yeah, in 2015, I think.
Yeah, it was about that. It was when this trial started.
Yeah.
Well, Jodi Arias took
That's from the Jodi trial?
Yeah, that's from the Jodi trial.
Three-hole wonder.
Three-hole wonder. You get it? But
I was thinking Clayton Eckerd.
For
a second. I thought there was something with the other girl.
Oh, yeah. No. That's Jodi Arias there. She's the only three-hole wonder.
I wonder how many times that's come out of the record.
We had a bingo because they were allowed jury questions. So after Jodi Arias was on the stand for 5.5 years, there were jury questions. So we had a bingo card on the jury questions. And the winners of that bingo card, will receive that mug.
What are you drinking out of today?
I drink out of Jody's holes. How about you?
Hey,
that's why people in civil matters choose to settle instead of going to trial, where it will become public record, televised even, and have us making memes about it.
Yes, exactly.
And then sometimes they get convicted and want to go through it again, like Mark Jensen.
Anyways, I just thought I'd share that. They came in yesterday, I think. But
nice.
They're really nice. So they're being sent out. I got to get individual boxes for these.
Thank you, Iron Rabbit. Gifted 5 memberships to For the Love of You, Charlene Grand Central Crafting, John Sherry, Moose Toyos, and Marian Newsom. Congrats. I should have Dave read this instead.
No, I don't read.
I don't mind reading.
No, Dave can't read names. It's so incredibly funny when you try to read names.
Yeah, I don't do names.
I just steamroll through names and just hope no one is offended if I get their name wrong, because I don't mean to be wrong. I get
all the names wrong.
Oh, I intentionally get them wrong.
I always apologize when I try to read names because I'm Swedish. I mean, our pronunciation.
That's no excuse.
My pronunciation of things are bad to begin with. For example, every time I try to say forequad, it comes out as fuck twat. I don't know why.
I think your English and your accent has gotten a lot better over the last year.
Oh, thank you so much.
Well, you get a lot of practice with us.
Okay. Who is...
I've got this.
Yeah.
You got it?
So, unlike pretrial comments, which the state is guilty of making, there is no basis for Mr. Williams' counsel to believe that his statement will have a substantial likelihood of material prejudicing an adjudicative proceeding. And then argument 2. Adoption of Mr. Stillwell's and Mr. Kendrick's motion for mistrial. So this is Doug Weinstein and also Max Shart's motion. We're going to see a third argument that deals separately with Bruce Harvey's. But here, Brian Steele and Keith Adams are adopting those motions for mistrial only if this honorable court finds that Mr. Williams was goaded into moving for mistrial based upon prosecutorial and judicial misconduct. And thus, retrial is barred. And there's a footnote. We gotta love those footnotes in his headers.
Oh, footnote.
So Mr. Williams does not join in Mr. Nichols. So that's Bruce Harvey's motion for mistrial without double jeopardy protection. So Bruce Harvey's motion's cool, but if you're going to do a mistrial without prejudice, we don't want us to co-sign that.
No. Do you really want to start over and allow this prosecution to do better?
What Nicholas is saying is that he'll entertain the argument of a mistrial motion, but only if double jeopardy attaches and the case goes away.
Yeah.
So
what's interesting here is that Harvey rule, we're all going to adopt things unless we say we're not adopting something. But here, Brian Steele's saying, I'm not adopting Harvey's motion unless this condition is also met. But Mr. Williams has been forced to remain in custody while the recused judge and lawyers, Love and Hilton, violated Mr. Williams' right to a fair trial, a fair tribunal, right to due process, and Steele's long laundry list of everything that he's always saying that was violated, causing Mr. Williams to be goaded into moving for a mistrial, as demonstrated by a few examples, as follows. So this example. Mr. Williams was denied his constitutional right under the Georgia Constitution and federal Constitution to be present at critical stages of his proceeding. See Exhibit A, that's the transcript of the ex parte meeting on June 10th. The recused judge, meeting with sworn witness Kenneth Copeland, was a critical stage of the proceeding in which Mr. Williams and his counsel had, as a matter of law, the constitutional right to be present. So they cite Scudder v. State. In the case at bar, the recused judge, Lawyer Love, and Lawyer Hilton unlawfully influenced Mr. Copeland to testify against Mr. Williams. And they're going down to the transcript again, the specific pages referenced in Exhibit B, the joint affidavit of Brian Steele and Keith Adams, and then, under the federal Constitution and Georgia Constitution, Mr. Williams was prejudiced by being wrongly excluded from this critical stage of the proceedings, where Brady evidence, judicial misconduct, and prosecutorial misconduct was captured and intentionally concealed from Mr. Williams and his counsel. Lawyer Love, and I like how that's a new line and it's still lowercase. Guys, this is a new sentence. The other one, to be fair, it's a lowercase below it too, but like...
Yeah, but this is with the Oxford comma, so
so it's not a new sentence.
Lowercase is proper here.
But usually when you format, doesn't it automatically capitalize and you'd have to go back and lowercase it anyway?
Yeah.
So they had the choice to leave it proper.
No, it's proper. It's proper now. He made the distinct choice to make sure that it was proper. That's all.
Yeah.
Okay. I do like
proper by his terms because he doesn't want it to be capitalized.
Props on the use of a semicolon, though. You don't see those often.
So Lawyer Love and Lawyer Hilton will be called as necessary witnesses in this trial by Mr. Williams, as material conversations with sworn witness Copeland are not captured on the transcript of the June 10th, 2024 unlawful ex parte meeting. So they're citing these specific parts of the transcript. So lines 3 to 10, and I don't know if you want to visit these after or whenever, but specific lines here we're getting. And then the specific parts on separate pages, as well as other matters wherein Lawyer Love and Lawyer Hilton must be examined as to other ex parte communications with the recused judge and concealed Brady Giglio evidence.
Yeah, I mean, the way they conducted that ex parte meeting, for me, it really sounded like, and this was a reoccurring event with problematic witnesses. And yeah, I would assume there are more ex parte meetings that we won't find out
for a while.
Unless Judge Whittaker, because Judge Whittaker has been speaking to what's her name?
Court reporter?
The court reporter for Judge Glanville a lot. Because I assume her commentary about the conduct in the courtroom and everything, all of that is from Miss...
Well,
I keep forgetting her name. Judge Glanville's court reporter.
She was also talking to the bailiffs too, and like everybody involved in this trial.
Miss Weaver, thank you. Yeah.
Miss Weaver. Okay. So she really came in and like the first thing she did is like, okay, what is your opinion about everything that's wrong here? And what is, like asking the bailiffs, or not. Oh yeah, I guess the bailiffs, about their opinions on what's wrong. And they're like, yeah, he had way too many clothes. And it's a huge security issue.
Yeah. The sheriff's office complained about the clothing of the defendants.
Yeah.
Because Mr. Williams tend to have a different outfit each day of the trial.
Yeah. And if you can get away with it, great. But I mean, it's still a security issue for the sheriff's office.
Oh.
Well, in Oakland County here in Michigan, you're only allowed one outfit per trial. So
really? Even for women?
Yeah.
Oh, yeah, because that was the Megan. Yeah. Yeah, and that is so that's a common thing. It's not just the.
Yeah, it's unfortunate because I think it's just as bad as showing up in orange. If you're wearing the same outfit every day, the jury sees you 7 days in a row. Most trials only go 5 to 7 days. But
I mean, I guess most trials are 2 to 3 days at most, but
yeah, so get 2 to 3 outfits.
But I mean, especially if you have a longer one. Anyway, sorry.
No worries. Everybody's shouting that Kat should read all of this, but let's have Dolly read this part.
Oh, a Dolly voice. Well, I'm also, by the way, I'm looking for Love's response. I'm trying to see the full document.
The recused judge violated Mr. Williams' constitutional right to confront prosecutorial misconduct when Lawyer Hilton introduced a known void, null, invalid, involuntary guilty plea before the jury. Specifically, Lawyer Hilton elicited testimony from Detective Rossi about an invalid, void, involuntary guilty plea, knowing that Same does not exist under law to push the prosecution's invalid theme that Mr. Winfrey was protecting the supposed/purported gang members now on trial in the case at bar. The recused judge refused to permit undersigned counsel to confront Detective Rossi and prove that lawyer Hilton was eliciting non-factual and knowing misleading testimony to the petite jury. This denied Mr. Williams his constitutional right to cross-examine witnesses, constitutional right to a fair trial, and constitutional right to a fair tribunal. See Exhibit C, Notice of Attorney Proffer, filed on July 1st, 2024, attached here too. Keep going. Lawyer Love has attempted to demonize counsel for Mr. Williams as well as the other accused counsel in front of the jury. This appears to potentially be Lawyer Love's standard practice. See Exhibit D, the appeal. Medical staff in notorious Atlanta jail let autistic teen waste away and die. Ooh.
That is the other case I'm following out of Fulton County.
Yeah.
Sean, yeah, the case of Sean, and it is so horrible. I will give you an example on how horrible. They found Sean unresponsive in his cell. It took the first hired medical personnel 5 to 6 minutes to get there, which is a 2-minute walk.
Oh.
She refused to perform CPR because she had a bad knee. Then her superior showed up a few minutes later, started to perform CPR, but was more or less thrown out of the jail cell because he did more harm than good. They couldn't, neither hired medical personnel could or wouldn't perform CPR. They have this mission, this heart starter, and the superior, the other, I believe his name is Michael or something, if I remember correctly, he couldn't attach it correctly.
That doesn't
because
here's the thing, though, with Love,
it's shown on the surface of the machine how to do it, and he couldn't.
But I agree with this first statement that Love has attempted to demonize counsel for Mr. Williams in front of the jury. And the thing is, though, is that I run into this a lot where the other side does this, and then you respond in kind, and then the judge barks at you. And you're like, listen, she's been doing it this whole damn time. You're going to yell at me because I did it the one time. It's extremely frustrating. I see it. I've seen Love do this, and I think it's good for calling her out on this. And I don't know this judge, but this judge seems no nonsense, and I don't think she's going to tolerate it going forward.
Oh no. I mean,
anyways, I just wanted to jump in and say I gotta jump off.
Yeah.
Kate was like, "Get out of here! Get out of here!
You're gonna miss."
Leave.
Well, I'm trying to find the. It's not Love that responded. It's Fonnie Willis that responded. Fonnie Willis has filed in response to defend Love and Hilton. She's responding to the motion to disqualify the lead prosecutors from the case. But guys, the link. So Dennis Byron had shared a link with where you can look at high profile cases in Fulton County and get the briefings. It's not uploaded there yet. And I can't use the Odyssey portal. It won't let me put my payment information in for Fulton counties. So AV to the 7th power. She says she has the same problem.
Okay.
So waiting to see if Joseph Babb will provide that. Guys, we could be looking at a Fonnie response today.
That would be amazing. I need to repost my video of her. I'll be listening in chat. I just got to get a few things taken care of.
Yeah.
Okay.
And I just got notified by potentially criminal. He might show up.
Oh, really?
Oh, that'd be so good for if the DA is writing filing a motion on behalf of the prosecutors in this case. It'd be great to have Sean on here.
Yeah.
Sean's a defense attorney, you guys, a practicing criminal defense attorney. Not you guys, but the chat.
Yeah.
All right, take care, all.
All right, bye, Dave.
Thank you, Dave. Bye-bye.
Yeah, I'd love to see him on here.
So, Fonnie Willis doesn't have the confidence in either Love
is that why
or Hilton.
No, she's defending them.
Oh,
okay, but
okay.
She's defending them, but is it because she doesn't have confidence in them to argue?
No, she has to defend them because they are the subject of the motion of this disqualification.
Okay, they would need another attorney to write it.
Then she must be in court to argue it. Guys, I told you now. Let's see here. There's almost 500 combined people on mine and Kat's channel. I said this a lot earlier. I've made sure I can leave work early because 8:45 a.m. is 2:45 p.m. my time. I need to get home early because Tuesday, 8:45 on the dot, we all need to tune in to this Foster clock. Because I don't know if Judge Whittaker expected this amount of replies, because I'm missing a whole lot of replies here from the state. And they had up until end of business today to file it. Now, it might take the clerk some time to upload it to the docket. So we might even see it until Monday. But just the mid-trial motions from Steele and others must be in their 20s that the judge just punted forward.
Yeah.
And then they still have to reply to everything the defense filed after Judge Whittaker took over.
And they all rely on something that you need to look back on the record for. So that's time consuming in and of itself. It's not, we want to introduce something new. Consider this new thing. It's all these things back on the record on day 30. Oh, well, I need Christina Weaver, who's currently working other trials, to get the transcripts over to me, which takes time. So this August 8th, if the trial is supposed to continue, this August 8th date that Whittaker tried to be somewhat optimistic to, even though she had some caution, she had some reserve. Yeah. But the jury coming back on August 8th, maybe. Yeah. That optimism has to be gone.
Oh, yeah. I mean, she's probably looking at the docket wondering what the actual F is. Because she wasn't a completely happy camper when she talked to the lawyers and the prosecutors. She set down really hard ground rules. She's an I don't take crap, no BS kind of judge. I haven't seen her in any trials or anything, but her demeanor there tells me, file it correctly, or I will rain down hell on you. And she says it in such a tone,
sweet tone.
That but once you hear what she says, just her way to say to the parties that if this doesn't happen, we have to have a talk. Yeah. You do not want to have a talk with Judge Whittaker. She will kill you with kindness.
Yes.
And this is the diplomacy. Now, my stepmother's brother is a diplomat. He has been in embassies on I won't say the exact ones, but some interesting areas of the world. You don't want to have a discussion with him where you find out you're wrong. Because he will just sit there, smile, he will rip your arm off, he will beat you with the bloody end of it, and you will still thank him afterwards. This is the type of lawyer I believe Judge Whittaker is, the type of judge.
And she said she wasn't really following it that closely, but either she's done a ton of research or maybe she has been, she knows enough to know where she needs to rein things in.
Oh, yeah. Now, where were we? I think it's my turn now. So sorry for you over at Kat's channel. I know you only want to hear from her, but this is a joint stream, so I will just say a little bit of things to rest Kat's voice, and then she will start talking again. Lawyer Love has attempted... Oh, we read that. This appears to potentially be Lawyer Love's standard practice. See Exhibit D, the appeal medical staff at notorious Atlanta jail. Prosecutional misconduct has been perpetrated by Lawyer Love from the inception of this case in order to goad Mr. Williams into moving for a mistrial. Exhibit E, motion for fair trial. The above few examples prove, in the event of any wrongful conviction of Mr. Williams, there is a substantial likelihood of reversal by an appellate court, including a court presiding at a motion for new trial. Therefore, the continued incarceration of Mr. Williams is punitive without legal justification. This past month and a half alone finds Mr. Williams helplessly trapped in a cell based upon the intentional misconduct of lawyers Love and Hilton and the recused judge. This delay in causing this honorable court to parachute into the case has infringed upon Mr. Williams' freedom. Respectfully, bond must be granted. This continued incarceration of Mr. Williams is unconscionable, as has much of this trial, under the guiding hands of the recused judge and lawyers Love and Hilton. The prosecutors and recused judge, Mr. Steele really likes saying recused judge.
Yeah, that'd be a dangerous shot counter.
Yeah. And for you who don't know it, Attorney Steele has a very good appellate, he's won a lot of cases on appeals. And he won twice against Judge Glanville. Yeah. I like Mr. Steele. I really, really do. I hope to meet him in some, maybe just in passing during lunch when I'm in the courthouse, unless Miss Lovett sees me and throws me in jail. I'm trying to get...
I would say the other thing, too, Dennis Byron had pointed out, with Whitaker on the stand, if the appeal reverses any decision from this point, wouldn't the reversal stick on her record? How does that work? Do you know? I don't know. We need... Maybe that's a Sean potentially criminal question.
Yeah, that's a Sean potentially
criminal. Let's bookmark that, you guys. Remind us in the chat if Sean pops on, potentially criminal, we'll ask him.
Okay, I will try to do I'm just reading and talking. I will try to make no.
I can read 6. I don't mind reading.
Am I done? No. The prosecutors and recused judge misconduct and trampling of Mr. Williams' constitutional rights has forced Mr. Williams to timely move for several mistrials after being goaded into same. This quote-unquote trial is not fit for a kangaroo.
It's not even a kangaroo court anymore.
It's not even a kangaroo court. Oh, the shade. The shade. Oh. All right. Now you're all over at Catnut Williams.
And then, by the way, chat, if you guys see the full document for Fani's response, or if you want to go and get it from the Odyssey portal, I'll cash app you. It's like 50 cents a page. But I just can't pull it up from the new link that Dennis Byron gave me. It's not uploaded to that yet. So if anyone wants to get the document, send it over to us. We'll definitely read it. But argument 6. Mr. Williams lawfully filed a statutory demand for speedy trial. No reasonable person would argue that a speedy trial has been satisfied. For example, the recused judge ordered Mr. Williams to be held in custody without bond since May 9th, 2022, while over 2,000 potential Veneri panel members were mostly individual vaudards for hardship. So that was remember when they did jury selection, they expected it to be 3 to 6 months that they would need to be sitting for this trial. And that was the time period, the constraint for hardship. There was no valid reason to summon over 2,000 potential jurors, since the petite jury was selected from the first 511 jurors, who were all summoned to the courthouse on January 4th, 2023. Undersigned counsel will be inquiring of the recused judge as to the reason that Mr. Williams had to endure suffering in custody, months of unnecessary individual jury hardship questioning. This unnecessarily elongated process of jury selection was a waste of time and violated Mr. Williams' constitutional and statutory rights to a speedy trial. This continual waste of time has caused Mr. Williams to be wrongfully denied freedom and a fair, speedy, constitutionally sound trial.
Yeah, I mean, the jury selection alone, how can that take 10.5 months? If the first 511, who was all summoned to the courthouse in one day? Now, it was amusing with the throwing a few of them in jail for recording in the courthouse. I mean, that's not a bright idea, and other things. But 10.5 months for jury selection is...
And then for them to pick the first ones anyway. Kind of like... And then I saw, Dave, I saw your chat to email you the information I need. I just DM'd you on X the portal link and the case number.
Okay, great.
That might be in motion. Thank you. And then, are we on 7, right? What's highlighted is new? Mr. Williams have given reasons for bond to be granted. We just read that renewed motion that came in this week. That was Tuesday that came in. In order to be released from the unlivable, inhumane conditions of the county jail that he has wrongly endured since May 9th, Mr. Williams has offered conditions of bond to include release with 24-hour surveillance by law enforcement. While Mr. Williams is not a significant risk of flight or a significant threat to others in the community, and thus does not need law enforcement to surround him, he has, however, offered this extreme provision if this honorable court wishes to apply that condition. However, under all circumstances, a pre-verdict bond must now respectfully be granted. The past will not be forgotten, but Mr. Williams' improper detention and unlawful suffering must end. Furthermore, counts of this indictment failed to allege at least one essential element of the crime. Thus, there is a fatal variance and jeopardy has attached to this. Thus, this case can never be retried and should be dismissed at this time, as a general demurrer can be filed at any time. So I guess that's going to be G. I don't know if that's new. The recused judge denied this timely filed plea in bar / motion to dismiss / general demurrer, and then denied a certificate of immediate review, and thus this Honorable Court of Appeals of Georgia dismissed Mr. Williams' direct appeal for lack of jurisdiction. And then skips to the bottom. Thus, the law of the case doctrine does not apply to Mr. Williams, and Mr. Williams asked this Honorable Court to decide this general demurrer issue so this case, or counts thereof, can lawfully end now. End now, instanter. So wherefore, Mr. Williams respectfully requests a hearing on this motion, and at the conclusion of same, asks this Honorable Court to grant the above requested relief. So put a 1 in the chat if you think Love is going to respond to this and say, Brian Steele didn't even lay out what he's requesting for relief.
Okay. We are only on page 12. Are the rest exhibits? Oh!
Yes, I think we got the trial transcript was the first one, so that's like long. Do you want to actually, let me pull up this motion, and do you want to go to the trial and I'll pull up the footnote?
The who, the what, the when?
Okay, so Thugger Daly saying the full document is inaccessible to me right now. The state is also expected to have filed other responses today, but since it's after hours, it's assumed that they'll come in Monday. So there's that part. So Thugger Daly might mean he's just on the run right now. I'm not on the run, but like doing something away from a computer.
Let's see here.
But let me pull up those footnotes so we can see the exact moment. It's probably going to be breaks in the conversation in the transcript.
Let's see here. What we have the initial page from Joseph Papp. We can go.
Yeah, let's look at that because that's where you get the big, like, this is the DA.
Let's see here at the stage. Oh, let me. There. In the Superior Court of Fulton County, State of Georgia, state's response to defendant's motion to disqualify lead prosecutors. The State of Georgia, by and through phony, whatevers, Willis, District Attorney of the Atlanta Judicial Circuit, hereby responds in the opposition of Defendant Jeffrey Williams' motion to disqualify lead prosecutors, Chief Deputy District Attorney Adrian Love, CDDA Love. Folks in the chat, what does CDDA actually stand for? Post your suggestions in the chat.
Chief Deputy is not the correct answer.
Not that C word, but other C words, because we like our streams.
Chocolate donut. Cookie dough. Cookie dough. All my guesses are going to be food. That's the way my brain works.
Yeah, so folks in the chat.
Dolly. I'm sorry.
Yeah, I'm okay.
Post your suggestions. Post your suggestions of what CDDA Love. Oh, with her last name, that can be interesting. All right, let's just continue. And Deputy District Attorney Simone Hilton, DDA, filed on July 10th, 2024, and on July 18th, 2024. Despite the extraordinary nature of the request to disqualify the lead prosecutors in this case, defendant cites no facts and no law that authorize this honorable court to disqualify either CDDA Love or DDA Hilton. Well, they explained quite thoroughly through their conduct in the trial, including not limited to the ex parte meeting and a lot of other examples. I don't think this is correct at all. Cites no facts, but they cite the ex parte meeting. Miss Love, I know you lie in church, but don't lie to the court as well. I mean, you can get away with lying in church because it's not punishable.
Well,
lying to the court and to this judge as the first action in this case with this new judge presiding. Oh, I want to hear the reply to this. Oh, the reply to that specific line from this motion from the defense. Oh, Phony Willis, you wish you were still in bed with Nathan Wade.
Don't we all?
Yeah, by the way, I don't know if... let's see if I can find it here. Yeah. For you over at Kat's channel, you might not have seen it, but I obtained images from the Aruba cruise with Miss Love and Nathan Wade. Let me show it. I'm quite sure that is authentic. I want if Miss Love doesn't put me in jail, Miss Willis might. And I will have content for years. The time I was thrown in jail by these hussies. Oh, did I say that out loud? Oh, sorry.
We'll contact the lead attorney to help save you.
The document is on that thing that I can't purchase from. I don't know why it doesn't let me. But it's saying that it's $4.50 total at 50 cents a page, so it's 9 pages long. So
did David?
That's actually longer than normal for considering the other ones.
Is David trying to get access to it?
Yeah, I think so.
Okay.
Unless he disappeared.
Well, that sounds like David.
Yeah. And I have another source that is also trying to get the full doc, but they can't access it either. So this might be...
Damn it,
I don't... Yeah. Damn it. Now, where were we? Accordingly, the state respectfully moves this honorable court to deny defense motion to disqualify the lead prosecutors. In support of this response in opposition to defendant's motion to disqualify, the state shows this honorable court the following. 1. Where defendant seeks to examine the prosecutors on matters concerning which there are other sources of evidence available to defendant, the laws of Georgia and the facts of this case mandate this court's denial of defendant's motion to disqualify. In support of his motion to disqualify the lead prosecutors, defendant asserts that lawyer Love and lawyer Hilton have made themselves critical witnesses in this case. When CDDA Love engaged in text messages with a witness and then CDDA Love and DDA Hilton participated in a hearing in chambers with a witness and his lawyer regarding contempt proceeding against, and that's all we have. That's all we have.
Dun, dun, dun.
Dun, dun, dun.
So yeah, and it's not, I know the jokes that Fonny's blocking this from becoming accessible, but I mean, maybe that was strategic in the timing that they filed it, right? That's a possibility, filing things late on a Friday, but which is stupid because they should know that all these YouTubers will go live on a Friday night to read their documents.
Yeah,
that's what we do for fun.
We have no life. I mean,
we'll do it.
We drop everything to go live.
Yeah. But it's the same. The portal I'm seeing it in is the same portal that's always a problem.
I'm guessing there's a lot of traffic, and it's just
it never lets me set up a payment account to pay for the document.
Oh,
it just gives me a 4014 error when I try to purchase the documents. So they don't want my money.
I don't need your stinking money.
I just put the long link in the private chat. I don't know if it'll take you to the document itself or make you try to create an account, but
yeah,
I'll try. I got 450.
Now, here's the thing. I can't ask of any of the lawyers in this case to send it to me because it needs to be filed to the court and uploaded to the docket.
You got to do it officially.
Yeah. So
did the image have the marking on it, or that would just be the electronic submission stamp?
I wouldn't want them to get in trouble either,
because it already says Clerk Shay Alexander at the top.
Okay, I have to create an account for Odyssey. I'm going to try this.
I don't know what it is. It's just been this the whole. I've never been able to add the account. I can just look and see that something new came in and see page 1. And then it's cool, page 1. Which was great the day that Brian Steele had 3 footnotes in a title on the first page. I could see a lot. But most of the time that doesn't show you very much.
Dun, dun, dun.
But I like reading Fonny's arguments, her writing, because she uses bold, underline, and italics all at the same time to emphasize things, every other paragraph.
Oh, she makes her motions look purty.
Well, and I feel like I can yell those parts when I read them. I can get louder. And no, I'm not using a VPN. Do you think that would help? I thought maybe,
Well, you're in America, right?
Yeah.
Yeah, no.
But I'm in, yeah.
I don't think it matters as long as you're in America. I know Hella has some issues because she's in Australia. Accessing court documents and stuff.
That's so annoying.
Yeah. Because I have to fetch them for her.
Shout out to Dolly. The document whisperer.
Yes. I'm trying to create an account and get it, so we'll see. Sorry, guys.
Oh, that's okay. It's a pesky website. It's this is their updated Odyssey portal too, by the way. And it's very clunky.
This looks like a government website to me.
What's interesting is Joseph Babb didn't get it either. And he's posted screenshots of it before, but
but you have the front page which we just read. That is what you see, and then you have to purchase the rest.
Yeah.
And that's a bit annoying.
Well, this one's only like $4, so that's worth it. But yeah, it is annoying.
Is it letting you create a payment account?
I haven't tried yet.
I'll be so happy for you and for us that read this document, but I'll be so annoyed if like you just magically figure it out. I've tried so many times.
No, damn it. No, server error in portal application. The resource cannot be found.
Refresh it. Try and refresh it. Maybe it'll do something.
No.
Because sometimes it won't show you the first page of the document until you refresh it, and then it suddenly shows it. And then Hank Deasy, thank you for the super chat. There is maybe an update on bond responses. I think that's responses to it, not an update on the decision from the judge. But Thugger Daily did say more motions. It's expected that more motions have been submitted by the state today. But it's just not going to show up until Monday because it's already so late on Friday. So one of those responses could be in opposition to those renewed motions for bond. So, and then the opposition really doesn't help. It's really what the judge would end up deciding. And hopefully that's the first thing addressed on Tuesday.
Yeah. And what's interesting there is so far during the trial, not one witness has expressed fear for the defendants. So how would... Now, you have Attorney Melnick's statement in an email, you're going to kill him. That's the one thing. I don't, in my personal opinion, now, folks, I am a bit biased. I admit.
Get him killed. And it doesn't mean by a defendant.
No, just that snitches get stitches. And if he talks to the cops in this case, he might talk to the cops in other cases. And there are... I've heard the rumors of other criminal elements in Fulton County that aren't these 6 individuals. I don't know if that's true or not, but yeah. Impeachment festival. Yep. I don't fear the defendants. They in jail. And here's the thing.
I was saying, I feel like I'm trying so hard to read 8 more pages. So I didn't mean to interrupt what you were saying. Just like...
I mean, especially if they claim Woody is scared of the defendants, Woody isn't afraid of anyone. No. I mean, he does not have fear. I mean, I would almost submit it should be the other way around. That people should maybe be scared of Woody. Because he's not nearly as oblivious as he portrays himself in court.
Oh, no.
That is a smart guy.
Oh, yeah.
And I heard rumors that once upon a time he was considered top 10 of dangerous individuals in Atlanta. You don't get that from out of nowhere. Just saying. Now, one thing I've been meaning to, now when we have Sal on and Kat on, I don't know if I asked this question, but what do you think about his statement in the ex parte meeting? I did these crimes. How is that not Brady material?
Well, it's definitely Brady material, obviously. I mean, I don't think he did it. I think he was just screwing with the prosecutor at that point. Because they're like, well, I'm going to give you immunity. So he's like, oh, yeah, well, I'm going to say I did the crime they did. So
I don't think it means he didn't do it either. It could just be layer on layer of just rewinding it and just, I'll just say this and then that and then this and then that and then this and then that. Like, you just don't know. The credibility is so far, like, his goal was to get rid of credibility, and he's done that.
Yeah. And, I mean, they can't say, like, okay, yeah, he's testifying against them, but at the same time, he's, like, doing everything to screw with the prosecutor and make himself not believable. Oh, yeah, I lie to the cops all the time. I tell them whatever they need to hear.
A little bit of truth, like what color, what the weather is, just so they'll like the spoonful of sugar for anything else that I need to tell them.
What color shoes are you wearing? What shoes you got on?
She made a LinkedIn post, Kristen Weaver, the court reporter. Really? Yeah, she's like, when you get brought into the trial on accident, and like a bunch of other court reporters, because you can see the job title in response, like, oh my God, I've had something like this happen to me. So it was just a LinkedIn thread of court reporter moments.
And like the next day he comes in, hey, I like your shoes. He's not, I want him to testify again so bad.
Oh, and that's true. Yeah, Fatima Barrett's adding, and then he also said, and then I'll lie. Like,
and then I'll lie.
But what were the lines that Brian Steele was pointing to in the transcript? I'll pull the pages if you want to go to the part of the transcripts. I can reference you what page to scroll to. That way you don't have to scroll. I have it up. I have the pages. So if you want to pull up the...
but I don't have it. Just post it as... Yeah. Or present it, or...
Have you tried to set up a payment account before today?
Yeah.
Okay, so it isn't just...
I'll wake up in the morning and see if I can download the documents today.
Okay. That's weird then. I was wondering if they were doing updates or something, but...
That's what I thought the first day, and maybe the second day. I'm like, wow, they're taking a long time to fix this.
Okay.
It's been multiple weeks. Probably more than 2 months now.
Oh.
I'm trying to create an account, but I don't have an American phone number.
Oh no, I sent the link below that for the document we already read. Because the transcript's an exhibit in there, but I want to see what lines Brian Steele was singling out to see if it's what, people on YouTube were saying. Hey, that sounds incomplete.
Michelle for $10. Thank you so much. Thank you so much. March 2023, Glanville ordered an investigation on who leaked the Woody video. What was the outcome of that investigation? I don't know.
Probably still pending. I don't know. That's just a guess.
Yeah, I would assume so. Now, once I get to the United States, I will get an American phone number because I purchased a phone and a blank phone, and then I will have one of these AT&T 30-day tourist internet thingy.
Well, David,
I just sent the title to him. It's state's response to, and I sent it to you, so you don't have to type it all. You don't need to write it down, but it's state's response to defendant's motion to disqualify lead prosecutors.
Like, if you have already a payment plan in this thing, then maybe you can do it.
I do not have a payment plan.
No, I know. None of us do. I'm hoping David does. Already set up when it was working.
So I have payment accounts in other Odysseys, just not, it won't let me do it in Fulton counties.
No, but my other source has, but she doesn't get it added. No, she has an account on the Fulton County, but she doesn't get it as well.
Well, I have an account now too, but you have to have a payment plan, and the payment plan link is what's broken.
Oh, that's crap.
Yeah, so it's like the resource cannot be found, the epayment.aspx link.
Okay, which line are we searching for?
Yeah, I think MLS God of Law is having the same issue. Okay, so the lines we're looking for. So first one was page 22. Oh, thank you, Kate Aiden. thanking us for working so hard for us. Like Dolly said earlier, this is what we do. We have no lives. This is fun to us on a Friday night.
This is what we know. What you see now is what we normally do. What you don't see.
Yeah,
Desperately trying to get hold of information. We just sit in front of the computer, often more silent, or a lot of cursive words, and go, "What the actual F? Why don't I get? Oh, that way." And then you find information from one source, a third source, or a fourth source. Okay, over there. I mean, every 1 hour stream is probably the same amount of time of research. And, well, except for Sal, who got, for you who don't know, Dali here requested the entire discovery of what's the case again?
The Rust trial.
The Alec Baldwin stuff, you guys. So, and the Hannah trial and Alec Baldwin's trial. So all the text messages, you have
body cams.
A very suspicious guy hitting on the lead detective. At least that's how I read the text messages.
Yeah.
You get to see how Alec Baldwin texts the detective to ask if he's if he's going to be charged with anything. All this good, juicy stuff. Really, really, really good stuff to look at, especially since the trial
ended.
Yeah.
It's so much fun.
Yeah. And Dali needs more subscribers and more people who watch his content, because somehow when he started to do the Baldwin after the trial ended, he get less views than normal. This should have been...
I know.
And so we are suspecting a shadow ban. So people, please, if you wouldn't mind, subscribe to Dali and make sure he gets some views in to break through that possible shadow ban. Now, this is not the first case Dali got all the discovery from.
Well, it's the one I'm most proud of.
Would you please, Sal, would you please explain to 500 people here, what case did you get the discovery from, and what was the discovery?
Mark Jensen. He was a man in Wisconsin, Pleasant Prairie near Kenosha. He unalived his wife with antifreeze. The man had a curious hobby of downloading and collecting photos of male people and organizing them by size. That all came out in trial twice, by the way. He got a retrial and had to go through the humiliation again.
Yeah. So Sal has on his computer how many pictures organized by size?
Well, only 800.
So if the FBI ever goes through any of us computers, our search history will implicate us as the search history we have is not of the normal people.
I was so happy to go with Baldwin, get a fresh start, get away from the degeneracy, just focus on a new case, be more professional, build up my stream, make a name for myself. And I'm forever linked to Mark Jensen.
It's Salvador Dali, the Peen Man. I'm sure you will find another trial that will overcome that.
I hope.
Unless we bring it up over and over and over again because it's funny. I didn't actually think you would get that discovery. And
I didn't either. I was kind of glad I didn't think I would get it. And then MLS David was like, well, I emailed Kenosha Police Department and got Zachariah Anderson's interrogation. I was like, oh, well, you don't have to contact the court. You can also contact police departments.
Yeah.
Well, I'm going to do that. And I was like, can I just get the discovery and all the evidence you have for Mark Jensen? They're like, sure. Here you go.
They're probably so happy to plop that on some unsuspecting person.
Here you go. They give you 2-3 gigabytes.
Oh my gosh.
Now, have we found out yet what the lines he is referring to?
Yeah, so the first one was on page, I think it was 21. Let me pull that window back up. I have a lot of windows now. Hopefully I didn't just close the one. Yeah, so page 22.
Page 22. 22! Okay.
And then lines 3 through 10.
But let's see, do I have it up? Yes, I have. But what we overheard being said was, quote, they are going to ham you, end quote, as if we were going to expose Kenneth Copeland too. Miss Bumpus, you heard that? Miss Love, yes, yeah, Mr. Melnick told Mr. Copeland we're going to hammer him. The court, now to be fair, and I think Miss Bumpus as an advocate or anybody has got to tell him he's going to face some pretty significant cross-examination.
Okay, so that's where he said to cite to on those pages.
Mm-hmm.
So maybe they mean that dash.
Oh, those dashes over here.
And then the next one was page 40.
Let's see if I can get it up into Google Doc. Oh, that looks like crap. Google Docs is not an option, by the way. Okay, next one.
Page 40.
Page 40.
And then lines 20 through 25.
Mr. Copeland.
The end of that paragraph? Well, so I guess it's maybe between that paragraph it's saying something was missing because line 20 is... Oh, wait. Page of the transcript, not page of the PDF. Are you on the page of the transcript or are you the PDF page 40?
I'm PDF page 40.
So go to transcript. Let's go back to transcript page 22.
25.
So let's start back at 22, transcript page 22.
Nine? Oh, too far.
Okay, so on 22, that was the lines 3 through 10. So yeah, so when Mr. Copeland's entered the chamber, I think maybe we're indicating that we don't know what happened before that. Maybe.
The proceedings stood in recess from 9:34 a.m. to 10:03. Okay. Mr. Copeland entered chambers at 10:03 a.m. Also present was Judge Glanville, Assistant District Attorney Simone Hilton, Attorney Kayla Bumpus, Court Reporter Christina Weaver. And the court, okay. So it's the gap between 9:34 and 10:03, what was discussed then. But it's just that the proceedings stood in recess.
And then the next one would be on transcript page 40.
Wait a minute, it's the page number on the bottom of the page.
Yeah.
Okay, let's go back to 22. Because I read the next page. Pages 3 to 10.
So wait, let's just pull up the transcript doc, because I think... Let me pull up the transcript. And I have it searchable, so we can search 22. Well, 22 will show up on every line. That's not a good idea. So this is the transcript then. Let's use the doc I just sent in the private chat.
Okay, let's see here.
And then go to page 22 of that. Good call, chat. Good call, Gavin.
I love that chat because they bring us in line. Let's see here.
Okay, so 22, 3 through 10. Is Glanville exiting?
Exited chambers at 9:33 a.m. And then they keep talking. Miss Love, we would like to just go into another courtroom and talk to him. Give you a chance to talk to him. And then give you an opportunity to explain to him. The court reporter, we're off the record. Brief recess. Judge Glanville and Mr. Chamberlain enters chambers at 9:34.
But look at the beginning. It's asking, is he here now? So then he leaves. He's obviously not in the room. Then Glanville leaves.
Yeah.
For whatever that, for that moment. It looks like one moment.
Yeah. Let's see here what is going on.
But that could have been, maybe he saw Hilton and Copeland like standing in the hall talking somewhere too for that moment, like glanced out, saw them. Which is why he said, I didn't inquire. I didn't try to look at video surveillance of what was going on in the hallway during this ex parte meeting. And I happened to notice this other video of Kayla and the defense attorneys all standing with each other. But maybe he was looking at those videos to see if he was popping out notably at that moment.
Yeah, Judge Glanville exited. Ms. Love, we would like to just go into another courtroom and talk to him. And then correct yourself, give you a chance to talk to him, and then give you an opportunity to explain to him, ... Court reporter, we're off the record. So Glanville exits 9:33 and enters again with Mr. Chamberlain at 9:34. And then they just pick up. Something is said in that minute. Even though...
Yeah, and I think if they were talking with Woody, Hilton could have been standing right in eye shot, and that something could have happened in that 1 minute. You don't need to walk very far if they happen to be right there.
Yeah.
So, and that would also be like pretty obvious to someone else hearing stuff. The next page was page 40.
Yeah. Miss Hilton has been communicating with him. I'd like to grab her from downstairs and have her come up. So at this point, it's only Miss Love there, not Miss Hilton. Where is Woody? Where is Miss Bumpus?
And Love obviously already knows Hilton is with Woody, right?
Yeah.
So...
Let's go to page 40. 40, okay.
And then lines 20 through 25.
What will get you in trouble is you just invoking your Fifth Amendment privilege because you have been given immunity. Or as Miss Love said this morning, remember, Miss Love said, if you overtly lie about something, like if you tell a bold-faced whopper, then they can indict you on that particular charge. I mean, that particular false statement.
And that was, so the third part was just that line 1 that you just read on the next page. So that's where we're saying something's missing. Now, what's interesting is none of the motions went into detail about these specific parts being where they think something was missing. But in this motion, here we're getting the specifics. So
yeah, that's weird.
That's why I think it's interesting, is because we've speculated, we've heard conversations about it. But we haven't seen a defense attorney zoom in on specific pieces.
Yeah, and Woody on Miss Bumpus' stream, Miss Bumpus asked Woody on her stream, is the thing complete? And Woody just did this and said, you know that.
Yeah, so the wording in the document is, we need to question Lawyer Love and Hilton as necessary witnesses in this trial by Mr. Williams, quote, as material conversations with sworn witness Copeland are not captured on the transcript of June 10th, 2024. So they're saying that paragraph right there and the other part, they're not saying might. They're saying they're not captured.
Yeah.
So Brian Steele has a further indication here of something.
He has talked to someone who might have heard something.
Yeah.
And I mean, Brian Steele has put his bar card on the line several times in this trial.
Oh, yeah.
Primarily because Ms. Love keeps lying to the court. There was this specific instance regarding what was heard in a video. And Ms. Love represented to Judge Glanville, there were only 3 lines spoken in that video in order to make Judge Glanville go and look at the video. And
I think he was telling on himself by trying to come at the others for being on a video in the hallway.
Yeah. Mm.
Have we confirmed who told Steele about the ex parte meeting?
It's not confirmed. It's highly probable that it might be Miss Bumpus.
Okay.
I think Melnick could be the messenger.
Yeah, Melnick.
Honestly, Woody could be the messenger. You never know.
Yeah.
Okay.
And
I think it's been released.
Judge Glanville strongly indicated it was Miss Bumpus, but I mean, there might be security personnel who is just fed up with the shenanigans. You don't know. We don't know. Hey, over at Cat's channel. GGT.
GG. So thanks for being so genuine. No, thank you, GG. GG's actually one of my favorite people to see in the chats too, by the way.
Yeah, you have a GG too. Because I have a GG.
Oh, is that
yeah, there's two GGs. Moderate. You have a mod GG.
Okay. Yeah. I thought she changed her profile picture. I was wondering.
No, but I always recognize by the G.
No.
And then your interaction with all your subscribers, paid members, super chat or not, is refreshing. I try. I actually feel really bad because I can't keep up with comments when it's like a stream that's live when a new motion comes out.
Yeah.
There's so much conversation in the chat that I can't. Like, I'll try to read something and it'll be so far off into a conversation that everyone's diving into in the chat. And I'm like, I don't know what we're talking about, so I'm just going to say hi.
Yeah. I mean, my chat has been so generous because during the winter, end of last year, Gigi, my moderator, had a medical issue that more or less put her in economic dire straits. And so I brought that up to my chat that if you, via PayPal, send and put Gigi in it, I will refer it to her because I don't want to reveal her actual name. And so far, I have been able to send over, I believe, something of the sort of $1,300.
That's really nice.
Because my chat just said, we need to help her because they lost their home. She had to move into her daughter's. Now they are moving out into their own home again, Gigi and her husband. And it's so good to see that my chat was a part of them being able to turn their economy around somewhat in order to be able to get their own home again. I mean,
moving sucks too. Yeah. Like, to be in bad spirits, to feel like an unexpected finance change happens, and then you've got to move during all of that. That is like the worst combination of things to happen all at once.
Yeah. Now I wonder, wait a minute, I have 10 gifted memberships from Iron Rabbit. And then I have this, and then I uninstalled another. I think we're at a spin of the wheel.
Well, while you're spinning, since I already know what I'm going to have to drink, I'm going to get my little teeny. This will be my first time ever having a drink during streaming hours.
Wow.
So I'll be right back.
It's Friday afternoon. All right, folks, you are about to witness the Wheel of Regret. It is a sour shot. What is a sour shot? This is sour cola. Hello, I'm Nick. I'm the one who doesn't have Coke on stream unless it's in liquid form.
How about cold SpaghettiOs?
So, what's the shot? It's about there. Might be a bit more.
I have
so this is what you get every $50 in super chats, gifted memberships, and or via PayPal. and 30 people left. Just because Cat left.
Oh, she'll be right back.
She will be back, folks. She will be back. Don't leave us. This is the difference between smaller. I mean, none of us are huge content creators, but Cat has more than me and Sal combined, subscribers and stuff. So yeah, but, yeah. This is sour. Cheers. But it's good. Once the sour disappears, it's actually good. Oh, but damn, that is sour. This is like liquid. What you call it? That candy thingy, sour candy thingy. What's it called? Oh, Snivels. Thank you. Gifted 10 memberships. Thank you so much. And it was gifted to, let's see here, Keysmobile, Tosha, Eric Rose, Emma. What the fuck? We're over 2 hours. Nullwolf Sarlus Wolfhound. Dime Philidiva. Kelly Waller. Janet Klinger. John Jones. Mimi. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Yeah. Thank you so much, Snivels. Now you have access to all my members-only content on my channel, which is a lot. But my members-only is more about me personally, like the farm, the renovations, my personal thoughts on things. So it's more on a personal level, so we get to know each other better. For instance, if you are Sal, you know this. What does the license plate of my tractor say?
Fork.
Yeah, I have a tractor. I have to find it. I have a tractor.
Am I good to go?
Yeah, you're good. Yeah, right. Oh, I already took mine. So, hey, Cat!
I couldn't find my cute little mug.
Oh, I thought you went to the store.
No, but honestly, it's Florida, so I probably could go to one that quickly.
That's fair. Yeah, I live in Mesa. Trust me, we've got an alcohol store on every block.
And they're open late here, too. When I moved down here, I was like, that's so weird.
Oh, yeah. They're open to like 2. Yeah, here. But they're classy and they close. No alcohol after 2 until 6 a.m.
Yeah, you gotta have that 4-hour break.
Yeah, God forbid. Gotta sober us up somehow.
It's spiced rum, you guys.
Ooh.
Although, when I went out, my roommate's birthday is coming up on August 5th. So, we're gonna have to get some other stuff in the house. He likes lighter alcohol, fruity drinks. I'll leave it at that.
Great. Yes, folks.
Mixed drinks, no shots.
I have a tractor that with a license plate. Fuck. That's my tractor. That is one of them. I needed a smaller tractor, but yeah, that might be the major reason I bought it. It seems has been cleaned up a bit. I need to rewire it and stuff like that. But yeah, that's my tractor. It is a Ferguson F15 from 1954. Thank you. Bliano Fever, he became a YouTube member. Hey!
Some of that old machinery is pretty good.
Member for 14 months. Thank you so much. Hey, Nick, long time no chat. Nice to be back. Welcome back. You have been gone for a couple of months now. Where have you been? I hope everything is all right with you, Rayman YYC.
You've got to do a little member emoji spam to celebrate that you're back.
Yeah. Yes. Member emoji thingy. Yeah, you have special. These are my members only emojis. You have glad Viking, happy Viking, loving Viking, and then I have the boomer moment because sometimes I mute myself without realizing it, and then my chat is banned with boomer moment. Then the tractor, female Viking, the three-hole wonder, as in a bowling ball, and then you have Jingles, who is my mascot. Jingles the cat, and then Christmas cat. Now, if you wonder who Mr. Jingles is, this is Mr. Jingles.
Aww.
Hello. Hello. Look how happy he is when I do this. He is so happy. He really enjoys me doing this, showing him to the audience. Look at this happy face. He is not plotting to kill me in any way, shape, or form.
No, not at all.
Oh.
I tried to get Babu, but he didn't want to.
I feel like I'm the only one without an actual cat. All I have is me.
Yeah, for you who don't
Oh,
know,
you're a cat.
we are all a part of the Mr. Jingle Viking Thug Gang. We might be a criminal conspiracy in the state of Georgia. And Mr. Jingles is our supreme leader. Three cats. Okay. I only have one because Mr. Jingles is chasing other animals away, or let's just say he stacked up in the barn of things just in case I didn't feed him. So he had 3 hares in a pile in the barn.
Jeez.
This cat catches hares.
Oh, here's Babu.
Oh no, Rainman, what was I was in the hospital for a few months. Had a stroke, been out and rehabbing for another few months. I'm so glad you're back. I did not know this. And for you who know about Mr.